following the foundation of fiduciary duties and the principles of single agency. It is essential to understand how disclosure and consent function in all Arizona agency relationships. Disclosure is the process by which a licensee informs all parties, clients and customers alike, of the nature of their professional relationship, their duties, and any potential conflicts of interest. Consent, on the other hand, refers to the written agreement and acknowledgement by those parties that they understand and accept the terms of representation. Together, these principles ensure that every transaction is transparent, compliant, and conducted with integrity in accordance with ARS Section 32-2153A3 and Commissioner's Rule R4-28-1101A-F. The Arizona Department of Real Estate, ADRE, mandates that agency relationships must be properly disclosed to all parties at the earliest practicable opportunity. This requirement stems from the fundamental fiduciary duties of honesty and disclosure. Whether a licensee represents a buyer, a seller, or both, the client has a right to know who the agent represents and how their confidential information will be handled. These disclosures help prevent misunderstandings and protect clients from conflicts of interest. In a single agency relationship, disclosure is straightforward. The licensee represents only one party, the buyer or the seller, and must disclose that representation to the other party at the time of initial substantive contact. This is typically done through the Real Estate Agency Disclosure and Election (READG) form, which explains to all parties the various types of agency relationships available under Arizona law. For example, when a buyer contacts a real estate agent to view homes, the agent must disclose whether they represent the buyer exclusively, the seller exclusively, or are functioning in another capacity. If the buyer decides to hire that agent, they will sign a buyer-broker employment agreement outlining the scope and terms of the representation. When representing the seller, a similar process occurs. The seller and the listing agent enter into a listing agreement that defines the terms of representation, including duties, compensation, and duration. The listing agent must disclose to any potential buyer or buyer's agent that they represent the seller exclusively. This disclosure is not just ethical, but required under R4-28-1101A, which emphasizes the importance of clarity and honesty in all agency communications. Disclosure becomes more complex in dual agency or limited representation relationships, where one licensee represents both the buyer and the seller in the same transaction. Arizona law permits dual agency only if both parties provide informed written consent, acknowledging that they understand the agent's limited ability to advocate for one side over the other. This consent is documented through the Consent to Limited Representation section of the READ form. Under ARS Section 32-2153A2, failure to obtain written consent before engaging in dual representation is a serious violation that can lead to suspension or revocation of the license. For instance, imagine an agent who lists a home for sale and then meets a buyer interested in purchasing it. If the agent wishes to represent both parties, they must immediately explain the dual agency situation and secure written consent from both the seller and the buyer before proceeding. Without this disclosure, any communication or negotiation could be deemed misleading, and the agent could be found guilty of failing to act in good faith. Dual agency requires neutrality. The agent may not disclose confidential information from one party to another, such as the seller's lowest acceptable price or the buyer's maximum budget. Disclosure obligations extend beyond agency representation to include material facts and conflicts of interest. If a licensee has a personal or financial interest in a transaction, they must disclose it to all parties involved. For example, if a broker owns an investment property being sold through their firm, that ownership must be disclosed in writing. Similarly, if a licensee is related to one of the parties or will receive compensation from more than one source, these facts must also be disclosed. The purpose of these requirements is to maintain fairness and transparency in all dealings, reinforcing the principle of honesty outlined in R4 28 11018. Informed consent is equally critical. The concept of informed consent means that clients not only receive disclosure, but also fully understand what they are agreeing to. In Arizona, consent forms must be presented in clear, straightforward language and signed by all parties before the relationship begins. This ensures that clients know the type of agency being created, the agent's duties, and any limitations on confidentiality or advocacy. For example, in a limited representation scenario, clients must acknowledge that the agent cannot fully advocate for either party's position, but will facilitate the transaction fairly. An additional layer of disclosure is required when one brokerage represents multiple clients in the same transaction through different agents. In this case, each client must be informed that their designated agent's fiduciary duties remain intact, but that overall supervision of the transaction is managed by the same employing broker. These intra-company relationships, often referred to as designated agency, are permitted under Arizona law as long as all parties are aware and consent in writing review summary. Disclosures and consent form the ethical and legal backbone of Arizona agency relationships. Licensees must clearly disclose their agency status to all parties, obtain informed written consent when engaging in dual or limited representation, and communicate any conflicts of interest. The READE form, along with written employment agreements, ensures clients understand their rights and the agent's role. Under ARS Section 32-2153 and R4 28 1101, failing to disclose agency relationships or obtain written consent can result in disciplinary action, including suspension or revocation. Ultimately, disclosure and consent preserve transparency, trust, and compliance in all real estate transactions. Discussion: why is informed written consent essential in dual agency? Answer: because it ensures both the buyer and seller understand the limitations of representation and agree to proceed, protecting the agent from claims of conflict or misconduct. What is the purpose of the READ form in Arizona real estate transactions? Answer: the READ form clarifies agency relationships for clients, outlining the types of representation available and securing their acknowledgement and consent. When must agency disclosure be made? Answer: at the earliest practicable opportunity, typically at the first substantive contact between the licensee and any party to the transaction. Closing remarks: agency disclosure and consent protect everyone involved in a real estate transaction: the clients, the public, and the licensees themselves. These requirements build transparency, trust, and accountability while ensuring full compliance with Arizona law. A licensee who clearly discloses their role and obtains informed consent not only fulfills their legal obligations, but also demonstrates professionalism and ethical excellence. The strength of the real estate profession lies in honesty and clarity, and nowhere is that more evident than in proper disclosure practices.